Ladies and gentlemen, my name is Isaac Christopher Lubogo at Sue Genes. Listen, today I want to make some kind of constitutional surgery in respect to things that have got to do with individuals or perhaps institutions that sometimes are given a spoonful of authority and they misuse that spoonful of authority to use them as if they have got drums of authority to the detriment of many unsuspecting people. Listen, my friend, we could have debates about individuals like Kiza Besigye, people like Amama Mbabazi, people like Baby Wine now, who have, in many cases, and other silent, innocent individuals who have suffered at the masses of what? Of, the powers that be. And perhaps that gives you the impression to look at my book called Demystifying the Order from Above. I know the Constitution is very clear. It's made provisions for, these armed forces, especially the police, and also the Police Act, Cap 303. But listen, the fact that the Police Act is mandated to do what they do in terms of exercising their rights, for example, in terms of preventative arrest or even, apprehending people, they should do that in consonant with other interpretations of the law. You see, there is an abuse, a blatant abuse, for lack of a better word, of individuals in the police who high-handedly manipulate or even overuse their power to the detriment of suspecting people. I'll give an example. First of all, let me make a dispensation in terms of what the law says. The Police Act gives the police the mandate, first of all, to arrest and to exercise, to prevent, to protect property, to prevent civilians or any other person in terms of orderliness for that purpose. But in doing so, they should do that with reasonableness, and they should use proportionate force, especially if there are instances when they are supposedly supposed to maybe, arrest or even stop people from committing omissions or even acts that would be detrimental to the populace or to the ordinary people, or even to the, institutions as they were, rather than simply holding this much authority in their hands to the detriment of the many people. And they end up hurting people in lieu of doing so. Yes, the Police Act Cap 303 gives them that mandate. No doubt about that. Look at Section 36. No doubt about that. Look at Section 26. No doubt about that. Look at the public order management. No doubt about that. But we are saying, even in doing so, we know very well that these so-called, rights are actually limited. They are, they're derogable. Okay, as provided for under Article 42, and therefore they can be infringed upon by virtue of what? By virtue of these individuals, these powers that be. But in doing so, they should exercise this power being consonant of, number one, proportionate first, number two, necessariness, number three, reasonableness. If you're exercising these rights, are you following those temperaments or those tenets, for example? It's very clear, even the UN principles of basic, rights of use of force, for example, it gives the presumption that if you're exercising or arresting or even in carrying out these obligations, you should carry them out with a discipline of proportionality, with a discipline of minimum force where necessary. Constitutional interpretation. Look at the case of Mwanga Kivubi, for example. The constitutional, petition of 2015 makes a very important dispensation in terms of it. It says when you're doing this thing, it should be not in terms of what they call anticipatory threats. It bars arresting or even infringing on individual rights when it comes to anticipatory threats. For example, if I'm assuming that this individual is about to commit an offense, anticipatory, without probable or reasonable justification for that purpose, then you should not do it. But you see, the problem with that is that sometimes this so-called constitution of ours, which has been written by the promulgators, has actually been misused or overused by these individuals to the detriment of other common people. And we see that sometimes these institutions have been given far-reaching powers. They exercise far-reaching powers sometimes to the detriment of the common people. Like I just mentioned, that case. But you see, even in the exercise of these authorities, individuals can actually be held culpable, civilly and also criminally. For example, if you look at the case of Mwanga versus what? Versus Attorney General. And a police officer was actually held, civilly liable. The Attorney General was held civilly liable in spite of the fact that this police officer acted out acts that were unwarranted, In other words, was an euphoric of his own. But in spite of that, still, the government was held liable. When you look at the case of, there's another case, a criminal case that had to do with Byarugaba. Okay, Byarugaba case versus Uganda. a police officer was held criminally liable, for acts and omissions, and therefore this liability can actually be imputed on these individuals if they act over and above those so-called powers. So even as you exercise this so-called right that you've been given, you shouldn't look at it as a one-way ticket to heaven, to the detriment of the many people, lest you find yourself to a one-way ticket to hell and to the burying of your own conscience. Listen, I meant what I said, and I said what I meant. God bless you. Once again, my name is Isaac Christopher Luga. Visit our books at lubogo.org and suegenesis.com.